I would like to frame the issue of this claimed right to abortion as resulting, I think, from conflicting notions of sovereignty. And the question of sovereignty is one that, from the beginning of the modern human rights project in 1948, has really been bound with it at its inception. Nick has spoke about the Nuremberg Trials, and if we recall the context of the Universal Declaration of Human Rights of 1948, it was just after the Nuremberg Trials had been completed. And the question, next one, of those who committed atrocities yet had broken no positive law arose. How would you judge these people who were acting, as members of the sovereign state of Germany? As Justice Jackson, who is the prosecutor, later American Supreme Court Justice, said that the last stand of those implicated was not that the evidence failed to convict of the acts, but the law had failed to make the acts crimes. Under the positive law, they acted accordingly. And what was interesting then, this notion that of a sovereignty that allowed a state to do with its citizens as it pleased was rejected. And the basis of the rejection, as Nick had mentioned, was the natural law. Justice Jackson, after the prosecution at Nuremberg, said that common law depends less on what is commanded by authority and more on what is indicated by reason. The judge reaches a decision more largely upon consideration of the inherent quality and natural effect of the act in question. He applies what sometimes has been called a natural law that binds each man to refrain from acts so inherently wrong and injurious to others that he must know that they will be treated as criminal. Okay? So this notion of sovereignty, the right of the state to do what it will with its own subject, is definitively rejected here, and also in the Universal Declaration of Human Rights. The drafters, Jacques Maritain and, as Jane mentioned, Charles Malik, were people who were very much concerned with the question of natural law as a grounding of that. But I think it's also important to stress that this modern human rights project is not a rejection of the concept of sovereignty per se. It's rather a rejection of a false notion of sovereignty. Consider this, that at the time of the drafting of the Universal Declaration, the founding of the United Nations, you had these new nations that were coming into being, okay, that were formed, these nations that were formally subjugated as colonial powers. The United Nations system is set up to accommodate their legitimate concerns, and indeed, the Charter of the United Nations reaffirms the principle of the sovereign equality of its members. Okay, so this then, is this inconsistent? No. It raises, however, a question of what is sovereignty in its proper sense. If I'm to ask you that question, what is sovereignty? What would you say sovereignty is? You give examples of what do you think when you think of sovereignty? On one hand, and I'm going to call you Grigori maybe to give us a self-determination of the nation state. You could talk about the juridical personality of the nation state as exists in international law. It has the ability to defend its borders, to enter into treaties and other such things. Sometimes this is called Westphalian sovereignty, after the Treaty of Westphalia of 1648, where these German city-states came into existence. Certainly that is one aspect of sovereignty. But we also talked about another aspect of sovereignty. Both our speakers here spoke about it, and that is the notion in a form of government such as we have, a democratic republic, who is sovereign? Pardon? Not the nation, but the people, the notion of the people as sovereign, democratic sovereignty. Source of political power, government by the people, of the people, for the people, as Abraham Lincoln said. So you have this idea of national sovereignty, the sovereignty of the nation in the abstract sense, democratic sovereignty, but ultimately, who or what is sovereign? We can speak, as the Declaration of Independence says, of the idea of the laws of nature and nature's God. We can speak theistically of God, but also in a somewhat abstract sense, the idea of a natural law, something that governs all conduct. So if you go back to Nuremberg, how is it that the defendants at Nuremberg were guilty? Because they had violated, in the name of a false sovereignty, the principle that there is an ultimate sovereignty that is grounded in the law of nature and of nature's God. Okay? This idea, if we could go to the next thing, the Declaration of Independence of the United States, I think, is very useful because all these concepts, this tripartite notion of sovereignty, is contained in the last paragraph of the Declaration of Independence. It says, "We, therefore, the representatives of the United States of America in General Congress assembled, appealing to the supreme judge of the world for the rectitude of our intentions." What sovereignty is that? Whose sovereignty? God, the ultimate sovereignty, right? It's an appeal to that. "Do in the name and by the authority of the good people of the colonies." What sovereignty is that? The people, the popular sovereignty, solemnly publish and declare that these united colonies are and of right ought to be free and independent states, that they're absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states they have full power to levy war, conclude peace, contract alliances, etc., etc. What sovereignty is that? Sovereignty in the sense of the Westphalian sovereignty, the ability of a nation to conduct its own affairs. And again, the reference to divine providence, the ultimate sovereignty there. All apologies to Jane because she's Canadian, right? And they didn't join us in declaring our independence, but nevertheless, that was a joke. Okay. Now, ideally, all these three sovereignties are in accord. So when you look at the laws of Poland with respect to unborn life, okay, not perfect, but in the European context, it's quite good. And the general principle of protecting unborn life is in accord with this tripartite notion of sovereignty, because ultimately the law that you've enacted, the positive law, attempts to base it on the natural law. It's consistent by and large with the natural law, and it's enacted through the people and through their representatives. Now, when Poland is called to task by members of the United Nations, and Stefano will talk a little bit more about that, but Poland has been repeatedly criticized and attacked by members of the international community. For example, UN treaty monitoring bodies like the Commission on the Elimination of All Forms of Discrimination Against Women, the Human Rights Committee, the Special Rapporteur for the Right of Health, in the European Court of Human Rights, the Tysiak case. Okay, repeatedly, these transnationalist bodies have attacked Poland. So when Poland defends its laws, okay, in an international forum, it's also defending that Westphalian right of sovereignty. So all these sovereignties are in accord with that. Now, we'll talk about international law. Can a state surrender its sovereignty, part of its sovereignty? Yes, it can. When a nation, for example, that otherwise would be free to, let's say, in trade relations, enact tariffs against other goods from other countries, it, however, enters into a free trade agreement, it commits itself, it gives up part of its sovereignty, the ability to enact trade tariffs, by entering into a treaty or an obligation. And this brings us to the question, what are the sources of obligation in international law? Principally, there are two. The first being treaty law, the second being customary international law. As you see here from this quote from the restatement, there is also this general principles common to major legal systems, next stage. I'm not going to focus much on that. It's something that is referred to in special circumstances, but principally it's the first two, treaty law and customary international law. Treaty law does become binding when a nation negotiates a treaty, when it signs a treaty, when it ratifies a treaty. Okay? Customary international law becomes obligatory from a general, consistent practice of states, followed by them from a sense of legal obligation. Let's talk about treaties treaties for a second. First of all, there is no global treaty that mentions a right to abortion. There's no global treaty. There's one treaty in Africa, the Maputo Protocol, that does mention abortion, but nothing binding on Poland mentions a right to abortion. And in fact, treaty law does support the right to life. Jane spoke about two of them, the Convention on the Rights of the Child that references the child needing special protection before and after birth. Even stronger, the International Covenant on Civil and Political Rights, which prohibits the death penalty against pregnant women. Whose life interest is being protected there? The unborn child. And thirdly, I want to cite, if we could go to the next, the American Convention on Human Rights, which is the most explicit protection of unborn life in international law. Every person has a right to have his life respected, and this right shall be protected by law and in general from the moment of conception. No one shall be arbitrarily deprived of his right to life. Now, it is inconceivable that nations that are otherwise sovereign to protect the unborn in their laws and oftentimes in their constitutions. A number of nations, like Hungary, for example, that amended its constitution 2 years ago to defend the right to life from conception, that by entering into these treaties, none of which mention abortion, that they had surrendered their ability, their sovereignty, the notion of the ability to make laws protecting unborn life. Yet that is the argument that is made by the other side. If we could go back to the previous slide, treaties are interpreted in accordance with common sense rules, with good faith in accordance with the ordinary meaning to be given the terms of the treaty in their context and in light of its object and purpose. Okay? Essentially, this means that words mean what they say that they mean. Okay? When a treaty does not mention abortion, when a treaty references the right to life, from which we can infer, for example, the International Covenant on Civil and Political Rights, that the unborn are being protected, okay, one can discern its meaning. But essentially, the claim of the other side is one that is inherently relativistic. Okay, it's inherently relativistic. It says that words do not mean what they say, but rather they say what we mean. Stefano will talk a little bit more about how this happens. Jane already referenced it. These various UN treaties create what are called treaty monitoring bodies. These treaty monitoring bodies, in effect, wind up reinterpreting treaties. It's a handful of experts that sit on these treaty monitoring bodies. They're not elected. They're not accountable to the people, okay, so, yet they are substituting their judgment, again, offending that notion of sovereignty in its fullest sense, to say that you must allow abortion. Briefly, I want to talk about customary international law, because as these committees give their opinions that are technically non-binding, they become sort of a body of soft law. And some people say, well, this then becomes customary law, so you have to change your laws on abortion. That is not what customary international law is. Again, that definition, it comes from a general and consistent practice of states, followed by them from a sense of legal obligation. Okay? The fact that we debate the issue of abortion in international law shows that there is no consensus on this. Okay? When advocates of abortion point to a trend showing liberalization of abortion laws, essentially, first of all, that's not international law. That's a survey of the domestic laws of other countries. So that's not international law. But even if you were to accept that principle, well, what is it that nations say? I would argue that rather than being a trend towards abortion liberalization, we have seen a trend away from that. Poland, for example, you amended your law, which was a permissive law on abortion, to one that protected life. You were not alone in doing that. Nicaragua did that. El Salvador has done that. East Timor has done that. Russia, we see doing that. They're dealing with their demographic crisis. Korea, just several weeks ago, the Korean Supreme Court rejected a challenge to their law on abortion. They affirmed the right to life. But we have also seen it in constitutions. For example, Hungary we mentioned. We also, the Dominican Republic in 2009, protecting the right to life from conception. We also have even seen in the United States the ban on partial birth abortion. So there is not this inexorable trend towards a right to abortion. States are standing up and they are defending life as Poland has. So that notion has to be rejected. Even sometimes you will hear people reference the Beijing Conference on Women or the Cairo Conference on Population and Development as somehow creating a right to abortion. These documents that are non-binding do not do that. In fact, they acknowledge the legitimate authority of each state in accordance with its legislative process to legislate on the issue of abortion. So even these documents that the abortion advocates sometimes use acknowledge the principle of sovereignty in its proper sense and accord nations that, that ability. Yet, nevertheless, activists use these cases, they use this transnationalist jurisprudence, the soft law jurisprudence, to bring cases in national courts and also in transnational courts to attack countries. Very important case in Colombia, where the Colombian Supreme Court, there's always a tension in a democracy between courts that are unelected, that are oligarchical, and the legislature. Courts are to interpret the law, they're not to create the law, but there's that temptation, what the United States did in Roe v. Wade. In Colombia, it was even worse than Roe v. Wade because what they relied on was these statements by these transnationalist actors, the treaty monitoring bodies, to create an obligation. I will just speak briefly about a very important case that is ongoing involving in vitro fertilization and Costa Rica. Costa Rica, that principle in the, if we can go back to the convention, the American Convention on Human Rights, that principle that life shall be protected from the moment of conception. Costa Rica bans in vitro fertilization because of this principle, because of what's contained in the American Convention on Human Rights. Activists associated with the Center for Reproductive Rights challenged the law. The commission, the Inter-American Commission on Human Rights, is this two-stage process. First, the commission issues an opinion, then they go to the court. The commission ignored Costa Rica's defense entirely. They did not look at this. They said that there's a right to privacy that forces Costa Rica to change its laws. They directed Costa Rica, even though they have no binding authority to do so, that it change its laws. Costa Rica, by one vote, retained its law protecting life. They now are before the Inter-American Court of Human Rights. We've done a brief on this very article, if people are interested, which we can send you, on what this portion of the convention means. It looks like the Inter-American Court will interpret this provision or ignore this provision and say that there's a right to in vitro fertilization in the American Convention on Human Rights. This is the dictatorship of relativism. It says that words have no meaning. Words essentially mean what we say them to mean, okay? It is that tyranny that Nick spoke about. And this notion of the sovereignty of self, okay? If we can go here, thank you. The Planned Parenthood versus Casey decision that Nick referenced. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, of the mystery of human life, okay? This is the autonomy, the sovereignty of self, but when it is imposed on others, is a denial of the basic human dignity. It essentially is what we saw in the garden, right? The sin. If you eat of the tree of knowledge of good and evil, okay, you shall be like gods. The ability to say that right is wrong and wrong is right, okay, that is the great temptation. And in so doing, I mean, we can talk about this, these competing notions of sovereignty then. The true notion of sovereignty, which ultimately is based on the natural law and its counterfeit. And if we could just conclude, where does this bring us? Where does this false notion of sovereignty bring us? And I think then, if we can quote from John Milton's great poem, Paradise Lost, "Here at least we shall be free. The Almighty hath not built us here for envy, will not drive us hence. Here we may reign secure, and in my choice, to reign is worth ambition, though in hell. Better to reign in hell than serve in heaven." Thank you very much.